Your Honor, good afternoon. Ian Pollenbaum for the Commonwealth.
Good afternoon, Mr. Pollenbaum.
Good afternoon, Your Honor. Kenneth Anderson for Nicholas O'Malley.
Good afternoon, Mr. Anderson. Good afternoon, sir. All right, Mr. Pollenbaum.
Your Honor, this is arraignment on a manslaughter charge. There will be a request for bail. I don't know if Your Honor intends to do the formal arraignment first or hear from the Commonwealth first.
Let's do the formal arraignment first.
Yes, sir.
Mr. Nicholas O'Malley, on docket 2602 CR 640, you're being arraigned on this matter. It's alleged that on March 11, 2026, you did cause the death of Stevenson King by assaulting and beating Stevenson King when they knew or reasonably should have known that the battery endangered human life, intentionally inflicting an injury or injuries likely to cause death, or wanton or reckless conduct that has a high degree of likelihood that substantial harm will result to another. Counsel, are you entering a plea of not guilty?
Yes.
Plea of not guilty entered. Defendant has been arraigned, Your Honor.
All right. Are there any requests by the government?
Yes, Your Honor. For reasons I'll also explain a little more at the end, the Commonwealth's request is for a $25,000 bail. Last Wednesday night, March 11th, there was a report of an unarmed carjacking on Tremont Street. A woman was in the passenger seat of her own car when a man got in the driver's seat, punched her and forced her out of the car and drove away in the car. A description of the car went out on the police radio with the plate number, and less than 15 minutes later, two officers, including Officer O'Malley, who's before you, found that car in an angled parking spot on Linwood Square in the Fort Hill area. Was parked nose in to the curb. The motor was running, and a man named Stevenson King, 39 years old, was reclined in the driver's seat. Officer O'Malley stopped the cruiser behind the car to block it in, and both he and the other officer approached the car with their guns drawn. The defendant ordered King repeatedly to show his hands, to unlock the car doors, and to shut the engine off. And the second officer also repeatedly told Mr. King to unlock the doors. Mr. King did show his hands, which were empty, but he otherwise didn't comply. Sat in the car, tried to say some things apparently, opened the window just a crack, but didn't unlock the doors or turn the car off. The defendant, immediately before or while he holstered his own gun and took out a taser instead, shouted at Mr. King, "Bro, I'm gonna effing shoot you." Immediately after the defendant made that statement, Mr. King put the car in reverse and he backed up into the unoccupied cruiser behind him. He then started maneuvering back and forth, either a 3 or a 5-point turn, going back and forth a couple of times to position the car to get out of the parking space. As he made the last reverse and started going forward again, the defendant drew his firearm again and immediately fired 3 shots into the driver's window. And it appears that all 3 bullets struck Mr. King, and 2 of them were found lodged in his body, causing his death. After Mr. King was shot, he drove away downhill on the street. It's a street that goes downhill, but the car crashed into a wall at the bottom of the block, and officers and then EMTs found Mr. King unresponsive, and he was pronounced dead at hospital. Immediately after firing the shots, and while King was in the car driving away, the defendant got on the radio. He called out 303, which is the police code for an officer-involved shooting, and then stated on the radio he tried to run us over. The investigation, including body camera footage from both officers, established that this statement was not true, that Mr. King was trying to drive away, maneuvering and clearly trying to drive away rather than run anyone over, and established that neither officer was in the path of the car or being in danger of being struck by it at the time. And both the video and a witness from a building nearby with a clear view of the incident confirmed this. The defendant was interviewed this week with Miranda warnings by the Firearm Discharge Investigation Team of the department. He did not claim self-defense. He did not claim trying to stop a fleeing felon. He said he fired his gun at King because he feared that the other officer was in danger of being crushed by the car when King maneuvered back and forth. The video established that the second officer was not in harm's way. He was off to the side of the car. He was directly across and, in fact, visible to the defendant, and at the moment of the shots was almost directly across the car from him and was in greater danger of being struck by those bullets than he ever was of being struck by the car. Both Massachusetts law and the department rules state that an officer may not fire into a fleeing vehicle unless it's the only way to protect the life and safety of the officer or somebody else. And in assessing this, we keep in mind the law and common sense that police officers get deference for split-second decisions they have to make in dangerous situations. For instance, there was a case from 2024 when an officer had a car driven at him, shot and wounded the driver. The officer ended up on the hood and shot and wounded the driver. Not only was the officer not charged and found to have acted properly, but the driver who survived was prosecuted and convicted last month. This, in our estimation, was not such a case. And although Mr. King was suspected of a violent crime and he was trying to flee the police, Commonwealth's contention in charging this case is that Officer O'Malley shot and killed Mr. King in circumstances that did not amount to proper self-defense or defense of another, and therefore didn't warrant deadly force. And therefore, he's been charged with manslaughter. The case will be presented to a grand jury for proceeding in Superior Court. Regarding the bail amount, the $25,000 request, that's not an amount that I propose or hope detains him for the months that this will take. It's also not a random figure I picked out. It's an amount that's about an eighth of the amount of money he earned last year, which was over $200,000. And I'm suggesting it as due to the seriousness of the case, recognizing his local ties and his work in the department, but that there should be some significant amount of bail for a case this serious. Unless the court has questions, that's my presentation to you.
Are you asking for any other conditions?
Yes, we are asking for conditions that he surrender all firearms, although that might have been done by the department already, and also that he have no contact with any person identified in discovery that he receives as a civilian witness.
All right, Mr. Anderson.
Yes, Judge, I'm not here to try the case today. This is obviously an arraignment. But what I will tell you is that Tuesday morning, my client and the other officer involved voluntarily went down to the Boston Police Homicide Unit. They were Mirandized. He gave a voluntary statement, and had the Commonwealth simply reached out to us and said, we're going to seek a charge. Can your client voluntarily surrender himself to the court, to a police station for booking? We would have done it. We weren't afforded that courtesy, and I don't know if it's because it's an election year or not, but I think it's kind of outrageous that 8 days after the fact, my client doesn't even have the firearms investigation discharge report, which probably won't be completed for several months. They go out and arrest him at his home. In terms of the conditions of bail, my client is 33 years old. He's lived his entire life in the state of Massachusetts. He was raised in Randolph. He went to Westfield State College after graduating from Westfield State College and University. He moved back to Randolph. He began working as a security officer, state police, certified officer with the Boston Medical Center. He worked there for about 5 years. He moved into Hyde Park during that time. He has roots in the community. He then began working. He was also an auxiliary officer in Randolph and Foxborough during that time. He got a job with the Providence, Rhode Island Police Department, commuting back and forth from Hyde Park, working at Providence, Rhode Island Police for 2 years. And then almost 6 years ago, he began with the Boston Police Department. He has an unblemished record. As you can see, he's very well respected, well liked on the job. He's married. His wife is present. His father's present. He's got a 3-year-old child. He's got a 6-month-old child. He is not a flight risk, and there's absolutely no reason to impose bail. If you look at the standard conditions in terms of likelihood of fleeing, roots in the community, none of those exist. And although it has nothing to do with my client's actions on that night, one of my partners did a little bit of research into the individual who was in the car that night, the decedent who had violently carjacked somebody earlier that night. But he was out on bail on 4 pending felony cases out of Suffolk County. So I think it's outrageous that they're asking for $25,000 bail on my client. If this individual was out, he had a Dorchester pending case, assault and battery in a person 60 years or older. He had an assault battery dangerous weapon case out of Dorchester District Court. He had an assault dangerous weapon out of Dorchester District Court. And he had a second offense firearm case out of Roxbury District Court. And I don't know if they asked for bail or didn't ask for bail in those cases. But I think when you have somebody here, 33 years old, worked his entire time to make the community safer, roots in the community, family, owns property, he lives in West Roxbury now, it's outrageous that they're asking for that amount of bail. So I would ask that he be released on personal recognizance. We have no issue with relinquishing the firearms. We have no issue with no contact with any civilian witnesses that may come up in discovery. But those are the only appropriate conditions in this case.
Mr. Palmerbaum, is your request about the no contact with civilian witnesses just for civilians?
Yes, it is, Judge. I mean, I think that
Your request
I'm
doesn't
not trying to
include other
parse
police
out.
officers?
I mean, half the district responded that night. I'm not asking that he be ordered not to have any contact with any of those people. I think.
Well, then why shouldn't he have contact with the civilian witnesses?
But I just assume he has no knowledge of who this civilian is.
Well, I'm saying if civilian witnesses come out of the woodworks or such, why shouldn't he be able to have contact with them?
Well, his attorney can, Your Honor, but I think it would be, and I'm not casting aspersions on the defendant for saying this, but I think for the defendant personally to be contacting any civilian witness in a police shooting in which he's charged.
Well, it's probably not wise if he doesn't do it through his attorney.
Correct, and would have, even through no fault of his, would have somewhat of an intimidating effect.
Okay.
Regarding, Your Honor, the Mr. King, the deceased, being out, just since the question was raised, that was in at least one court, maybe more, over the Commonwealth's repeated objections that Mr. King was out.
All right, we're not litigating anything regarding the decedent here. So I'm going to ask that you both refrain from referring to anything about that individual. Any other requests on behalf of the government?
No, Your Honor.
All right, I'm setting bail at personal with the condition that the defendant surrender any and all firearms. Next date.
We're asking by agreement for May 20th, if that's possible. I'm sorry, May 21st.
That's fine.
Mr. Nicholas O'Malley, on docket 2602 CR 640, you've been arraigned on this matter. A not guilty plea has been entered on your behalf. Attorney Anderson has filed a notice of appearance. There is no legal counsel fee. You're being released on personal recognizance with the following condition: that you surrender all firearms. This matter is going to be continued to May 21st, 2026. It'll be on for probable cause. It'll take place in the third session down the hall at 9 a.m. You're recognized to appear in person on that day and time. Please be advised, if you're arrested or violate any condition of release while this case is pending, your bail could be revoked and you could be held without bail for up to 90 days. Before you leave, sir, please check in with probation, sign the conditions of release form, and you'll be all set. Have a nice day, sir.
All right, thank you.
All rise.